My name is Melissa Frias, and I'm part of the Citizens Review Panel team. Prior to that, I was working as a child's best interest attorney for the Guardian ad litem program. Today, we are going to be discussing the path of a case, from that initial abuse call all the way to permanency. So without further ado, let's begin. You're going to see a list of our partners and stakeholders. I'm sure you've heard the phrase that it takes a village to raise a child, and that's certainly true in the child welfare system. There are many people that are involved in our child welfare system to ensure that all things keep running smoothly. This is not an exhaustive list, and there's certainly other people involved, but some of the players is the Department of Children and Families, Citrus and its case management agencies, the juvenile court judges, the Guardian ad litem program, Miami-Dade County Public Schools, Florida Foster Care Review, of course, us, community-based service providers, universities, and community funders. Like I said, there are many other people that are involved in the child welfare system, but these are some of the people that are key in making sure that everything runs properly for our children and families. There's one agency that you will definitely come to meet when you're discussing your cases, and that is Citrus. As of July 2019, Citrus became the lead child welfare agency for the Southern region. This has been a fairly new change, so there might be some things that change. But for now, we wanted to give you an idea of some of the things that Citrus does in-house. One of the things that Citrus takes care of is intake and triage. We're going to discuss that later in our presentation. Citrus also does family services. And in this case, when we say family services, what we mean is services that are provided to the family on a voluntary basis. So these are actually cases that you won't see because they don't come into the court system. But Citrus is involved in providing this family with referrals and with ensuring that they get the services that they need, so hopefully, if everything goes well, they don't have to come into the system. Citrus is also in charge of the Extended Foster Care Program, which you will hear referred to as EFC. I'm not going to go into the specifics of the requirements and the benefits that come with EFC, but what we wanted you to know is that when a child turns 18, they are not thrown out of the dependency system. They actually can remain in the Extended Foster Care Program, and that comes, like I said, with a lot of benefits. Citrus also has a nurse case manager, and the nurse case manager takes care of providing medical services, usually at the beginning of a case, and then also to those young adults that I referred to in the Extended Foster Care Program. They can actually go to the nurse case manager and ask questions about scheduling appointments and being able to arrange certain medical services. Citrus also does quality assurance and data collection. So they collect data and look at trends about what's going on in the child welfare system so that then they can work together to bring improvements to our system. They also do foster home licensing. So all the background checks that go into foster home licensing and all of the prerequisites that go into licensing a foster home so that it's safe for our children. They also do IT development and records management. So they actually collect the data from all of our cases, and they have a database where the case managers upload their documents to. And lastly, full case management. And this is a task that you will become very well acquainted with because it's the one that we deal with the most. What we mean by full case management is that Citrus actually subcontracts the case management part of services to other agencies. So rather than directly serve our families day in and day out, Citrus has subcontracted with agencies that are out there in the field providing services on a daily basis. Citrus is still involved with all of our cases, but these subcontracted agencies are the ones that deal with the families day in and day out. The agencies that you will deal with are Children's Home Society, which is known as CHS, the Center for Family and Child Enrichment, which is known as CFCE, and Family Resource Center, which is known as FRC. There's also Wesley House, but they deal with cases in the Keys, so you likely will not see them. So now that I gave you a little bit of a background about the players that are involved in the child welfare system and some of the people that you will be meeting, let's get down to the law. So now that you have a little bit of background, let's talk about separation of powers and fundamental rights. So who creates all these laws? They're created by the legislative branch. The legislative branch creates the laws that then DCF, which is the executive branch, has to enforce. The judicial branch is then in charge of making sure that these laws are applied evenly. Together, they make up our three branches of government, and they keep each other in check and ensure that there isn't abuse of power. And the reason that that's so important is because we're dealing with a fundamental right. The right to parent is a fundamental right. It's the right to make decisions over a child's education, health, religion, and ultimately, if the department terminates a parent's rights, they will be infringing on that fundamental right. And that's why we need to ensure that due process takes place throughout our process in the path of a case. We need to ensure that the parents have notice of hearing, that they're appointed an attorney, and that the proper procedures take place. One of the biggest areas that changed in child welfare was when the Adoption and Safe Families Act came out. There was a big shift in the way things were handled in child welfare because at the core of it now came safety and permanency. And this is something that holds true today. When you're doing your reviews, you're going to always be asking yourself two questions. Is the child safe, and are we moving towards permanency? And that's something that I want you to remember throughout this presentation, safety and permanency. And when I talk about permanency, what I mean is that we want our children to be in their forever home. We don't want our children to linger in foster care. And for some children, that might mean returning to their parents. That's always our primary goal and what we want our children to be able to achieve. But as we know, that's not always the most appropriate goal for a child, and that's not always what ends up happening. But what we want to do is be able to find a permanent family for our children so that they are no longer in the dependency system. So when you hear me say permanency throughout this presentation, that's what I mean. So now that you have a little bit of background on how child welfare laws came to be and some of the core reasons why we have them, let's talk about how a case even gets to dependency court. The first thing that has to happen is an abuse call. So someone calls the abuse hotline, which is 1-800-96-ABUSE. A person observes either abuse, abandonment, or neglect and calls the hotline. They then relate to the person what they observed. That person takes down all those facts, writes down as much information as they can, and they contact the Child Protective Investigator, which you'll hear the term CPI. The Child Protective Investigator will then go out to the setting where the abuse, abandonment, or neglect occurred, and they'll gather information from people firsthand. They might speak to neighbors, to teachers, to the parents, and even the children themselves, and gather information about the home, about the situation, to assess for two things: present danger and impending danger threats. The only way that a CPI won't go to this assessment process is if they find that the case is just completely false or unfounded. So unless it's unfounded or a false report, the CPI will then move on to the next step. The CPI has to take the least intrusive actions to ensure the child's safety. And they have to determine if the family is in need of ongoing services. If you remember, when I was talking to you about Citrus, I said that Citrus is involved in intake and triage. And this is what I was referring to. Citrus is actually part of this process. The CPI will set a case transfer conference, and in that conference, they will determine what sort of services the family needs. They might determine that the family needs voluntary services, and these are called non-judicial cases. Non-judicial cases don't come into court, and so you'll never see them. The cases that we do see is when they determine that court-ordered services are necessary. At that point, the case then comes to court, and DCF files what is called the shelter petition, and we have the beginning of our case. In front of you, you're going to see the path of a case. There's a chart that shows you everything that's going to go on in a case, and I encourage you to reference it, print it, whatever works best for you, and follow along. I will be discussing all of these hearings, and you'll be able to see how a case flows through the dependency system. For your own reference, all of the laws that I will be citing, or at least most of them, come from Chapter 39 of the Florida statutes. And so you can definitely look in there to see some of these laws and how they play out. So now that you know how a case gets to court, let's talk about who you're going to see in court. As part of your pre-service training, you'll do a court observation, and you're going to see that there's a lot of people in the courtroom. And who are these people? In a dependency case, we have both parties and participants. And it's important because parties have different rights that participants don't. Parties have the right to file motion, they have the right to receive notice of hearings, and participants don't have those rights. In dependency, our parties are the state, the parents, the children, and the guardian ad litem. It's important to note that the children and the guardian ad litem are two different parties. The guardian ad litem is appointed by the court to represent the child's best interest, and not every case has a guardian ad litem. The children themselves are parties to the case, and in some cases, the court will actually appoint an attorney ad litem, and the attorney ad litem has to represent the child's express wishes. So the attorney ad litem represents express wishes, while the guardian ad litem represents the child's best interest. Those are our parties. Now let's talk about our participants. Our participants are the case managers, the providers, it might be a therapist, a teacher, it might be a relative, a custodian, the foster parents. And the participants offer us a wealth of information, and we want them to come to court and share that information with us, but it's important to remember that they are not parties and they don't have the same rights that parties do. Now that you know who these people are, let's talk about that very first hearing. So 24 hours after removal, we have the shelter hearing. It happens immediately after removal. The case comes to court, and DCF has to show why was this child removed. They have to prove that it was justified, that the child was removed from the home. And at this point, the burden is actually very low, and the burden of proof is probable cause. Assuming that the allegations are true, DCF has to prove that the child was either abandoned, abused, or neglected. At this point, the court will also look at reasonable efforts. Did DCF make reasonable efforts to prevent the removal? Did they offer the family voluntary services? Or is it just that the case was so severe that the removal cannot be prevented? If the court finds that the removal was justified and that DCF made reasonable efforts or that there were no other efforts that could be made in this case, then at that point, the court will enter a shelter order. A good way to understand this is because we can't just remove children on a whim. I talked about how this is all about a fundamental right and how it's so important that the proper procedures take place. Well, this all links back to that. The court is going to look at the case and ensure that this child's removal was justified. There are other issues that are addressed at the shelter hearing. Even though it's early on, there's a lot that goes on at these hearings. And in front of you, you're going to see a list of some of what these issues are that are addressed at the shelter hearing. So let's go over those. One of the things that the court is going to look at is the whereabouts of the parents. So in abandonment cases, you might not know where one or both of the parents are. Or it might be that the case came in, but one of the parents has not been identified. The court is going to try to do everything that they can, and the department and the parties to try to identify where that parent is. And the court might order what is called a diligent search. And what this means is that the department has to make efforts to find the parent. It means looking at last known addresses, job locations, social media, getting information from relatives, and trying to find the parent so that they're aware that there's a case. And the reason that this is so important is because there might be a parent out there that is interested in assuming custody of the child and does not even know that the case exists. So the department has to make efforts to find the parent and notify them about the case that's going on in court regarding their child. And eventually we'll also have to serve these parents. The whereabouts of the parents is also linked to paternity. The court also has to find the father for each of the children. And I say that because some of your cases might have 6 children in the case, and they might have 3 different fathers. The court has to ensure that they establish paternity for each of those children. And the way that they do that is first by looking at the birth certificate. They might see if a father signed the birth certificate. If they did, then that's the father. The other way that they try to investigate who the father is by finding out if the mother was married at the time of birth. If she was, that person is the father. If neither of these options lead us to the father, then the court will begin to ask questions and inquire with the mother, with relatives about prospective fathers, and try to find those prospective fathers and bring them into court. Once they're in court, they can either affirm that they are the father, and the court will enter a final judgment of paternity, or they can request a DNA test, which often in court they call it an HLA test. And it's the same thing, And at that point, they'll determine if that's the father or not and enter the final judgment of paternity. If none of those options lead us to a father, the court can enter what is known as the no legal father order. But overall, what's important to remember is that we need to find a father for each of the children in our cases. Next, the court will discuss placement. So the child has been removed from the home, and as we all know, foster care can be a traumatic experience. And so the court has an obligation to ask about relatives. And our statute tells us that relative placement is preferred if it's safe, of course. So the court will ask, are there any relatives, non-relatives, neighbors, friends, anyone that is willing and able to take custody of the child? And they'll do backgrounds and home studies to see if that home is approved. The court will also discuss visitation. So even though that child was removed, we still want to make sure that they have visitation with their parent and their siblings. Of course, again, if it's safe. So there are different types of visitation that the court can order. The court can decide that the visitation has to be supervised by the agency, meaning that the visitation will happen in a facility and that usually the case manager or sometimes they have a visitation supervisor will observe the visit. They'll determine if the visit can be supervised by a relative. So if, for example, the child was placed with the grandmother, the court might find that the grandmother can supervise the visits with the parents. Or in some cases that are more severe, perhaps more traumatic, the court might decide that the child needs therapeutic visitation and that a therapist has to be the ones to supervise the visits. In some cases that are either very severe or because of the circumstances that brought it in, the court might decide that there should be no contact and enter a no contact order between the children and the parents. This also happens when we don't know the whereabouts of the parents, and the court might enter a no contact order until the parent appears before the court. And at that point, the court will then establish visitation. Like I said, it's not just about the parents, it's also about the siblings. So a lot of the time our children are separated. And in that case, we want to make sure that we preserve that sibling bond, and the court will also enter sibling visitation orders. Another thing that is discussed during the shelter hearing is child support, and that is based on the parent's income. They will discuss education. So where is the child placed? Is the child getting any specialized services? And we want to try to preserve that as much as possible. And the court will make efforts to try to maintain the child in the school that they were in. The court will also ask about counseling and services. At this point, the court can't order the parents to do services, but they can certainly order services for the child. Like I said, therapy is usually the most common one, but there might be other services that are needed, and at the shelter hearing, the court can enter those orders for the benefit of the children. And then finally, psychotropic medication. At the shelter hearing, the court will ask for a release of records, and this relates to both education and medical records, and it's to find out what medication is the child on. Psychotropic medications or not, we want to make sure we have those prescriptions and that we continue whatever medication the child needs. The reason for this is because we want to preserve normalcy and balance as much as we can now that the child has been removed from the home. So at the end of all of this, the court will enter a shelter order summarizing all of the findings that we just discussed. The next step is the verified petition for dependency. So now more time has passed. Remember the shelter hearing, the shelter petition, that happens really quickly, 24 hours after the removal. The verified petition for dependency happens 21 days after the removal and can happen earlier, but they have 21 days to file the verified petition for dependency. So at this point, the department has had more time to evaluate the case, gather more facts, more evidence, and they entered what is known as the charging document, the VPD, or the verified petition for dependency. And what this document has is it tells us what the parents are charged with. So what are the allegations that the department is raising against these parents? The allegations have to relate to three things: abuse, abandonment, or neglect. The department will then have a higher burden of proof. Like I said, more time has passed, they gather more evidence, so now the burden of proof is higher. It's preponderance of the evidence. So more likely than not, they have to prove that the allegations in the petition are true by a preponderance of the evidence. At this point, the parent will be served with the petition and will be aware of what the allegations are against him or her. So arraignment occurs 28 days after the removal. And at this point, the parent has been served with a verified petition for dependency, and they can take a plea as to the allegations. So remember that this is not a criminal proceeding, so the parent won't be pleading guilty or not guilty. In dependency, the parent can either admit, deny, or consent. If the parent admits to the plea, then at that point, they're basically saying that everything is true and the allegations are true. If the parent consents to the plea, which is far more common, they're not saying that it did happen, they're not saying that it didn't happen, they're basically consenting to the allegations, they're consenting to the department giving them services. Or the parent can deny. If the parent denies, then that means that they're saying it's absolutely not true, and the case at that point will go to trial. If we go to trial, which is not common, like I said, usually the parents will consent. They'll accept services and will go on to that phase of the case. However, if they do deny, then it goes to trial. And in this case, that is known as the adjudicatory hearing. So the adjudicatory hearing is a trial to determine if the child is dependent. And at that point, the department will have to prove the allegations against the parent. Like I had said before, it has to be either abuse, abandonment, or neglect. And the department has to prove that at least one of the allegations are true. So for example, if the department's case involves domestic violence and substance abuse, and they go to trial, but they're only able to prove one of those allegations, for example, the domestic violence component, then the child can still be found to be dependent, but we won't be able to offer the parent services having to do with the substance abuse. And we'll talk about case plans in just a minute, but I wanted you to understand why it's so important that at trial, the department is able to prove each of the allegations, because ultimately that will determine our services. If the department prevails at trial, the court will then enter the adjudicatory order, or if the parent admitted to the allegations or consented. That's when we get our adjudicatory order. And the reason that it's so important is because in that order, the court will delineate the facts that will then make our case plan. So let's get to that. In the case plan hearing, the court will determine what services the parent needs to complete. Oftentimes, during the disposition hearing, the court will address the case plan, but sometimes they won't, and they actually will set a different hearing that is known as the case plan hearing. Before the case plan hearing is the disposition hearing. This happens 30 days after the adjudicatory hearing, which is that trial to determine if the child is dependent or not. At the disposition hearing, the court will look at placement, will look at services. It's basically a checkpoint to see how things are going. At this point, the case manager has been assigned to the case, the guardian has been assigned to the case if there is one appointed. They've hopefully been out to the placement, they've been able to meet the child. And at the disposition hearing, the court will gather information about what's going on and discuss things like placement and services that are needed. And like I said, at this point, the court can discuss the case plan, but oftentimes the parties might not be ready and they might set it for an actual case plan hearing. So what do we do at the case plan hearing? And why is this case plan so important? The reason the case plan is so important is because that's basically what a parent has to do to get their child back. In order to reunify with the child, in order to regain custody of the child, the parent has to complete the case plan. And so that's why it's so important that it links back to the adjudicatory order we discussed and the adjudicatory hearing. Whatever the facts are that were proven, those are the facts that are going to make up our case plan. And it has to be geared towards remedying the situation that brought the case into care. So just like I said earlier, if the department was not able to prove the substance abuse allegations, or if the parent did not consent or admit to the substance abuse allegations, then those services won't be coming into our case plan, even if they were back in the shelter petition. These tasks have to be very specific, and they have to be the least intrusive possible. And again, remember that this is all about being able to get our children back home. So we want to remedy the situation that brought the case in and be able to safely reunify children. That's also why these tasks have to be very specific. Case plans have to include information about where the services are going to take place, who's going to provide the services, how long do the parents have to be in services, and case plans expire. At minimum, they have to expire within 12 months. Now, as I'm sure you know, or you will know once you start hearing your cases, unfortunately, some of our cases go past the 12-month mark. But at minimum, the case plans have to be at least 12 months. They can't be 13 months, 18 months. If later on the case plans have to be extended, there will be a case plan hearing, and the court can decide to extend the case plan. However, they do have timelines, and they do expire. And that all leads back to permanency. We want to be able to achieve permanency efficiently and as quickly as possible. The case plan is also signed by all parties. So we want to make sure parents understand the case plan, go over the case plan, and sign it. It's important for you to know that throughout all of this, parents have the right to have an attorney. So even though this is not a criminal proceeding, parents do have the right to have an attorney because this is a fundamental right. So when I'm discussing this adjudicatory hearing and the case plan, all along the parent, if they decided to, they will have the counsel of an attorney. The court will appoint an attorney all the way at that first hearing, at the shelter hearing. If the parent is indigent and they can't afford an attorney, the court will appoint one for them. If not, they certainly have the right to go out and hire an attorney. So at the case plan juncture, this is something that the parents will discuss with their attorney and make sure that they understand what they need to do to regain custody of their child. Another thing that happens at the case plan hearing is that the court will notify the parent that failure to complete the case plan could result in a termination of their parental rights. So if the parent fails to do the tasks in the case plan, they might lose rights to their children. At this point, the case plan has been entered. The parties know what they need to do. The parents engage in services. Hopefully, everything is running smoothly. And then we get to a judicial review. That's a really important hearing for you to know about. And the best way to think of a judicial review is sort of a checkpoint because it happens at the 6-month mark and then 6 months every time thereafter. So, like I said, parents hopefully are engaged, the child has been in their placement, 6 months have passed, the case is moving along, and we get to a judicial review. The judicial review is actually the only hearing that the Citizens Review Panel can hear. We don't hear trials, we don't hear evidentiary hearings, we don't hear case plan hearings. The only hearing that we hear is the judicial review, if the court refers that case to us. And that's why it's so important for us. It's also just in general a very important hearing to find out where the case is at. At the judicial review, the court will make several findings, and they're going to be discussing education, health, compliance. Because it's such a big hearing with so much information, 72 hours before that hearing, the agency will file a report that is known as the JRSSR, which stands for Judicial Review Social Studies Report. Judicial Review Social Studies Report, but it's commonly known the JR or the JRSSR. 72 hours before this hearing, the agency has to file this report, including information about everything that's been going on in the case. The case manager will provide recommendations, will let us know how far along the parent has come. Are they halfway engaged? Are they almost done with parenting classes, for example? And they also will include information about the child, about their education, about their health, about their placement. Not only will there be that report by the case manager, but there's going to be supporting documentation. And so as panel members, that's what you're going to be reviewing. And it's important to look for that supporting documentation because if, for example, the case manager says that the child went to a doctor's appointment on August 22nd, you're going to look into your documents and find out if you have that child exam from that day and look for recommendations. What happened at that appointment? Likewise, for the parent services, if the case manager says that the parent is progressing in their parenting course, that they're doing well, we're going to be looking for that parenting report and supporting documentation to find out more about what's going on. Because this is such a lengthy report, and it can be anywhere from 30 pages to 100 pages, we have that 72-hour requirement that the agency has to provide them before, so that all the parties have time to review and prepare their objections, their comments, or how they want to supplement the JRSSR. The Guardian ad litem program also files a Guardian ad litem report at the judicial review. And that's another report that you will be receiving. So now that we have all our documentation, the JRSSR has been filed, we're ready for a judicial review hearing. And at the judicial review hearing, the court will make several findings. One of those findings are compliance findings. So what compliance means is, are the parents compliant with their case plan? Are the parents substantially complying, meaning that they're engaged, they're usually probably done with their services at that point? Are they partially compliant? Maybe they just started, they're getting the hang of it. Or are they not compliant at all? We might not know where the parents are. They might not have gone to services at all. And that's what we're going to discuss at the judicial review. The court is not only looking to the parents, but also to the department. And the court will then also look to see if the department has made reasonable efforts. If you remember, I mentioned reasonable efforts all the way at the beginning of the presentation. At the beginning, the court will look to see if the department has made reasonable efforts to prevent the removal. At this point, the court is going to look at if the department has made reasonable efforts to achieve permanency for the child. So how is this case moving along? Has the department made all the appropriate referrals? Have they provided the parent with a bus pass, for example? Are we moving the case along? And in that case, the goal would be reunification. If the goal is adoption, then the court might ask the department, what adoption efforts are they making? Is the child in adoption recruitment websites? Have we looked at relatives that may be interested in adoption? So the court is looking at compliance findings for both the parents, if it's still reunification as the goal, and as to the department. The court at this point can also order reunification if it's appropriate. So remember that we said case plans expire in 12 months, but ideally, we don't have to take 12 months to reunify a child. If at this hearing the parents have substantially complied and everything is as it needs to be, then the court can order reunification. And in your pre-service training, you're going to go into more detail about Florida's practice model and what it takes for a parent to get into reunification, which we won't discuss, but it's just important for you to know that that is one of the things that we're looking at in judicial reviews. Is this child ready to go home? Alternatively, if that's not the case, at this point, the court can also authorize the filing of a termination of parental rights petition. So remember I said the parents might be in non-compliance, their whereabouts might not be known. And the court also has the authority to authorize the termination of rights petition being filed by the department. So like I said, this is the type of hearing that the Citizens Review panel hears. We hear judicial reviews. And so all these findings that I just discussed and all these things that we'll be looking at are the same things that you as the panel members will be looking for. We're going to be looking for compliance, we're going to be looking at reasonable efforts, and we're going to be looking at permanency. And we're going to be asking ourselves, what can we do to ensure that this child achieves permanency? And if you're asking yourself who attends these hearings, it's everyone that we discussed when we talked about parties and participants. The parents, the department, the children, they're all part of the judicial review. And just like they go to court, they'll also be coming to the CRP hearings. And our participants, the case managers, perhaps the relatives, the custodians, they're all part of these judicial review hearings. And remember, parties and participants are different, but these are all important players at judicial reviews because we want to gather as much information as we can so that we can help move the case along. At the conclusion of the CRP hearing, you will be making the findings that we discussed, and you'll be making recommended orders. So the findings that we make are recommended findings, and the orders that we make for services for the child or for permanency, for services for the parents, these all are recommended orders. that then the court decides if to adopt or not. But it all relates back to that judicial review hearing where we look at compliance, we look at reasonable efforts, we look at permanency, and then we look overall at the well-being of the child, education, health, placement. The judicial review hearing for children that are 17 years and older is a little bit different. The reason is because if a child is 17 and still in the dependency system, at this point, we have to start focusing on how do we prepare this child for adulthood? How do we prepare this child to enter the real world? And so these hearings actually occur more often, and they're called 17.3 hearings because we want to make sure that we're on top of it, just like parents in the community when their child is about to turn 17. Does the child have a driver's license? Do they have a bank account? Do they know what they want to do after graduation? Do they know where they want to live? We also will hear these sorts of cases, but the questions that we ask and the information that we gather might be slightly different because it's really focused on ensuring that the child is prepared to enter the real world. During your pre-service training, like I said, you'll be learning more about the extended foster care program, the PES program, and what the options are that are available to a child. But what we wanted you to remember is that just because a child turns 18 doesn't mean they just leave the dependency system or that we stop holding judicial reviews. The next main hearing that you will see in court is the permanency hearing. And so you've heard me say the word permanency a lot throughout this presentation. But we have this one hearing that is actually specifically designed to address permanency. And this hearing happens every 12 months. So just like I said that the judicial review happens every 6 months and 6 months thereafter, the permanency review has to happen every 12 months. So unfortunately, a case might be open for 3 years, for 6 years, and every 12 months, we will be hearing the permanency hearing. At the permanency hearing, the court will be addressing just that. Is the permanency goal still appropriate? So if the goal is reunification, the court will be looking at the compliance of the parents, the progress, are we close? Is the child able to safely return home? If that's not the case, at that point, the court might decide that the most appropriate thing to do is to change the goal to something else. The court can evaluate permanency at any juncture. And so the court does not have to wait for the permanency hearing to change the permanency goal, but they can certainly do it at this hearing, and they're going to be taking a closer look at the permanency during this hearing. So I just talked a little bit about how the court can change the goal, and you're probably wondering, what can they change that goal to? So let's discuss that. There are 5 goals that are recognized by Florida statute, and they're in order of preference. In the slide in front of you, you're going to see what these goals are, and they're ordered in the preference that the statute requires. The first one is reunification. That is our most preferred goal. Ideally, we want all of our children to return safely to their parents, and that's why that is our number 1 goal. In order for a child to be reunified, there are certain conditions that have to be met. And the practice model will guide you into knowing what that is. And like I said, you'll discuss that during your pre-service training, but it's important for you to know that the case manager will design a plan and will tell us during the judicial review whether the conditions for return have been met, and that's one of the questions we're going to be asking. So if we're looking at reunification, we're going to be asking, is the home calm and consistent? Have the parents met all the conditions that they need to meet? Are the parents willing to abide by a safety plan? Have the parents engaged in services? They gained insight. Are we at that point? That's reunification. And reunification can occur with either of the parents, and it's our most preferred goal. Unfortunately, that might not always be the most appropriate goal for our child. And in that case, the second most preferred goal is adoption. Adoption can only occur if the parents' rights have been terminated. And so that's why at the beginning I said that it was so important to ensure that we locate all of the parents and that we establish paternity. Because in order for a child to be adopted, the parents' rights have to be terminated first. That's why this is our second preferred goal, because what happens when a person adopts a child is that they become like if they were part of their biological family. Legally, they are no different than a biological child, and that is why the parents' rights have to be terminated. In order to adopt, the person has to go through different procedures, has to apply for adoption, and ensure that this is the appropriate placement for the child. It's considered a permanent home, and it's lifelong. Once you adopt a child, it's like if they were your own child for the rest of your life. It's different than permanent guardianship, and that's why I wanted to stress why adoption is our preferred goal. Permanent guardianship is a little less permanent because it's not lifelong. Legally, the relationship ends at 18. Now, the permanent guardian and the child might have a bond and a relationship for the rest of their lives. We're just talking in legal terms, the permanent guardianship ends at 18. And so it's a little different than the adoption. The permanent guardian also doesn't have to apply for adoption. The requirement in this case is that the permanent guardian have successful custody for at least 6 months. And the parents' rights do not have to be terminated in this case. That is our third most preferred goal. Then we have permanent placement with a fit and willing relative. This goal is rarely used. And the reason for that is because it's not really permanent. With this goal, the department still has to supervise the case, and it doesn't close. And if you recall, that's what we said permanency is being able to find a permanent forever home for a child and closing the case from the dependency system. With this goal, the case doesn't close, and that's why it's rarely, if ever, used. The fifth goal is another planned permanent living arrangement. Another planned permanent living arrangement, commonly known as APLA. APLA is used for children that are 16 and over, and that the court has found that none of the other goals that I just discussed are appropriate. In that case, the court might decide that the most appropriate goal is APLA. If the child's goal is APLA, it means that the child was not reunified, was not adopted, there's not an adoptive candidate, and there's no permanent guardian at the time. So that child will actually remain in the system. And at that point, the goal of the case or the focus of the case might shift to focusing on ensuring that child has all of the things that they need to prepare to age out of the system. But it's important to remember that a goal can change at any point and that we can work concurrently towards a goal. And so, for example, if the court has decided that the child's goal is APLA, but at some point an adoptive candidate comes to light and the court finds that the most appropriate goal is adoption, they can certainly change that and pursue the adoption. Goals can change at any juncture in the case, but during the permanency hearing is where we'll be taking a closer look and deciding if the current goal is appropriate or if we should change it. The court is continuously reviewing permanency goals. At the judicial review hearing, we're going to be looking at it. We as panel members are going to be looking at that and really deciding, are we moving this case along and is this the right plan for this child? And finally, how does the case end? So as I said throughout, the case ends when the child achieves permanency. And that could be through adoption or a permanent guardianship, or in the case of reunification, after the court reunifies the child with the parents or one parent, the court then has to wait 6 months to be able to close the case. And at that point, one of the parties might file a motion to terminate supervision. So after reunification, the court has to keep the case open for at least 6 months to keep eyes on the case, make sure everything's going as it should, that the parents are doing well, the child is doing well in the home. And if everything is going well, six months after reunification, the court can decide to terminate supervision. And at that point, the case closes. So finally, I want to circle back to that chart that we discussed at the beginning of our path of a case. This chart that's in front of you right now is slightly different. This one has timelines that we've discussed throughout. So you can look at when these hearings occur and how they flow throughout the year of a case plan. Ideally, our cases would close within 12 months, but often they don't. However, it's important to remember that that is our goal. We are always working towards permanency, and we want to achieve that as efficiently and as safely as possible for all of our children. I look forward to working with you on that goal. Thank you for listening.